Hi, everyone. Welcome to the Responsible Use of Artificial Intelligence Training for Eastern Illinois Area Special Education. I'm Tony Reeley, Executive Director. Our training today is mandatory for anyone who will be granted access to Playground IEP or any district-approved AI tool. We'll not be covering how to use Playground IEP. Rather, we're just going to be talking about an introduction to EASE's AI plan, talk about some AI literacy concepts, and potential issues with using AI. Our attorney, Brandon Wright, will also address legal issues with using AI in schools.
Hello, everyone. I'm Brandon Wright, an attorney with Franczek PC, and my role today is going to be to help make sure that while you're using these tools to save time, you aren't accidentally creating a legal mess. We're going to talk about how to use AI without violating student rights or the law.
In this first section, we're going to look at why we need a formal plan and who's responsible for keeping it updated. AI is moving fast, and we didn't want to just say no to these tools because we know that they have potential for helping with drafting and differentiating instruction. But because AI is different than something like a calculator or a word processor, it brings risk like data leaks or hallucinations. We're giving you the keys to the car, but only after we've taught you how to drive it.
And from that legal standpoint, we have a lot of legal considerations here. The Office of Civil Rights has already started issuing warnings and guidance about discriminatory outcomes from AI. Illinois has also passed some laws and preparing guidance related to potential discriminatory uses of AI. We also understand that there are many data privacy and confidentiality concerns that are an important component to the legal considerations that we're going to talk about today. So by requiring this training and by you participating in this training, we're trying to establish that standard of care, right? To protect you by making sure that you've been briefed on the risks before we start inputting student data or using AI.
So we've adopted 5 core principles within our AI plan. The first one is that it's human-centered. AI supports us. It doesn't replace us. The whole plan is centered around this idea that it is a tool that we use. We don't rely 100% on it. We also want it to be transparent. We don't hide the fact that we use these tools. We want it to be equitable. We have to ensure that AI doesn't reinforce stereotypes about our students. Also, that it's secure, that our student data stays in a vault and it's accountable. At the end of the day, you and I are responsible for what's in the IEP, regardless of who drafted that first version.
So as Tony mentioned, right, AI is a tool, it's not a decision maker. And this is, I think, the most important legal distinction in our training and presentation today. AI is a generative tool. It is not a decisive tool. And under the IDEA, decisions regarding eligibility, placement, and services, like all other aspects of the IEP, must be made by the IEP team, a group of humans. If a placement decision is ever traced back to an AI recommendation rather than a team discussion, that could be a procedural violation of the IDEA. So while AI can help you summarize data, it cannot decide what a child needs or make decisions that must be an IEP team decision made up of the IEP team members designated by the law.
We have a lot to cover. By the end of this module, you will understand the fundamentals of how these systems work, identify the red lines for prohibited uses, and understand your personal obligations regarding student privacy. We want you to leave here feeling confident that you can use Playground IEP without accidentally stepping into a legal trap. To use a tool safely, you have to understand the engine under the hood. In this section, we'll strip away the jargon and look at what is actually happening when you type a prompt into AI. At its core, AI is a system that processes massive amounts of data to find patterns. What we're using today is called generative AI. It's important to realize that the AI doesn't know your student. It doesn't understand the law. It's a prediction engine. Think of it like a superpowered version of autofill on your smartphone. It predicts the most likely next word in a sequence based on the patterns it learned during its training. It's designed to be plausible, but not necessarily factual.
And because AI is just predicting the next word, it can and will make things up. This is what we call a hallucination. An AI platform may confidently cite a medical study that doesn't exist, or describe a student progress on a goal that was never actually implemented. In a legal document like an IEP, a hallucination is simply a lie, right? If you copy a hallucination into a student's file, you are the one responsible for that factual error, not the software company. So we need to be very concerned about that we have that review and make sure that we are not relying on hallucinations, but on the facts and the data we have regarding the student.
Let's talk a little bit about the limitations of AI. AI is limited by the data it was trained on. It doesn't have common sense, and it doesn't have a heart. It might suggest a goal that is technically correct for a grade level, but completely inappropriate for a student's specific sensory needs or for family context. It cannot replace the nuanced understanding that you have from working with a child face to face. It is a text generator, not a context understander. We must always supplement AI output with our own professional observations.
And I think one of the other significant dangers and concerns is what we call automation bias, the tendency to trust the computer more than your own eyes. And if you get tired and you start clicking accept on every goal that the AI platform drafts for you, you are abdicating your professional responsibility. From a liability standpoint, you are the author of every word you submit. If you wouldn't write it yourself, don't let AI write it for you. And that's why we've got to maintain that human in the loop at all times to make sure that we're meeting that legal obligation that the IEP remains a personalized, individualized document for this student. So be very careful about over-relying and underestimating the human component that's necessary for legal compliance.
And that human in the loop requirement that Brandon was talking about is a non-negotiable standard for us. It means that between the AI's draft and the final document, there always has to be a human expert who reviews, edits, and validates the content. AI is the assistant, but you are the boss. The assistant can bring you a draft, but the boss's name goes on the letter. You are responsible for the accuracy, tone, and compliance of every word in that IEP. You must read every line. You must verify every measurable goal. You must ensure alignment with baseline data, and you must modify language to reflect your student's specific needs. AI does not finalize documents. Professionals do.
So let's dig into the legal framework with a little bit more finesse here. You know, the legal framework for AI in schools, and particularly with IEPs, is not just one law. It's a combination of several laws: the IDEA for special education requirements, as well as the Illinois School Code, FERPA and the Illinois School Student Records Act for privacy, Illinois SOPPA for data security. These laws all create kind of a triangle of protection, a framework we build upon. And when we ignore any one side, right, the whole structure collapses. And so we want to make sure that we are remaining compliant with each of these pillars: our special ed requirements, our privacy requirements, and our data security requirements. So let's talk first about those IDEA obligations. When we get into the core fundamental requirement of the IDEA, we are creating an IEP. That IEP is by definition an individualized education program. And AI, by definition, is built on generalization rather than individualization. There is a natural tension here. And if we rely too heavily on AI templates, we risk creating cookie cutter IEPs that don't meet the legal requirement that an IEP be tailored to the student's unique needs. We risk losing the I in IEP. So we can use AI to get a draft started, but you must finish it by making it specific to that child's unique circumstances as the IDEA requires of us. And, that comes to us directly from the NJREF standard, right? We're all familiar with NJREF, right? The Supreme Court's 2017 decision that set forth what is an appropriate IEP, and that to make sure that an IEP be reasonably calculated to enable a child to make progress appropriate in light of that child's circumstances. And so AI is great at drafting standard goals, but standard isn't the legal requirement. Our goals must be ambitious and must be individualized. And if AI drafts a goal that's just adequate or de minimis progress, and we don't push it to be more ambitious and tailored to that specific child's potential and needs, then we aren't meeting that NJREF standard. And so while AI may be able to suggest a baseline, it is you as the professional educator who has to build on that baseline in order to make sure that that goal is ambitious and appropriate. The other legal framework we've got to think about are the civil rights laws that apply. The Office of Civil Rights, as well as the Illinois Department of Human Rights, are already looking at this. They've warned that if AI tools consistently suggest lower level goals or more restrictive placements for certain groups of students, that is a civil rights violation. And we can use these tools to assist our work, but we never let the algorithm dictate the level of service or the placement of a child. If AI generated content results in, lower academic expectation for certain groups, like students with disabilities, more restrictive behavioral framing, more punitive language for some students than others, then those outcomes definitely create exposure to civil rights concerns, even if that bias was unintentional. So it's got to be a fundamental piece that we are keeping in mind with our obligations. OCR has issued guidance on this and is actively watching how schools use AI. And their guidance has been clear. Schools are responsible for any discriminatory impact caused by the AI tools that they use, even if that bias was unintentional. And this is why we vet our vendors so strictly. We are looking for tools that have that bias mitigation built in, but the final line of defense against bias is you, the professional. You are where we ensure compliance. Another piece that's important from that legal standpoint is that we are not, having decisions made automatically, right? This is a hard red line for us, right? We do not use the algorithm to decide if a student is eligible for services, what their minutes should be, where they should be placed. These are high stakes legal decisions that must be made by the IEP team, right? AI is for drafting support only. It is never used to replace that deliberative process of the team meeting by the people the law requires to be present and participate, obviously including the parent as well as part of that decision-making process. Ultimately, right, the IDEA creates a statutory responsibility with the district and the licensed professionals to make decisions. The district and you as the educator have that legal duty to provide FAPE to students with disabilities. We cannot delegate that duty to a machine. If an IEP is found to be deficient, AI wrote it is not a defense. You are ultimately still the legal author of the documents you produce. And by using these tools, you are asserting, right, that you have reviewed and you have verified the contents. That is the expectation going forward. If and when you use it, you are verifying that by virtue of your use of that platform. So let's talk about a situation, a scenario here. Consider this hypothetical, right? A parent alleges that the IEP is generic, that it is not individualized. They point to repeated phrasing across multiple students, and they ask whether AI drafted the document. In that situation, I think the district is going to have to be able to document that staff were trained, that AI was used for drafting support only, that human review occurred, and that the goals were tied to this student's data. right? And based on this student's needs. And if we can demonstrate those safeguards, if we can demonstrate that process that is compliant with IDEA, then we are in a much stronger defensive position if that claim comes in.
Section 4 is the do's and don'ts section. We're going to talk about the boundaries that will help determine whether your use of AI is considered responsible or if it's considered misuse under our policy. Let's be clear about what is authorized. Playground IEP is the only AI drafting tool authorized for everyone, EASE employees as well as member district staff who have completed this training. In addition, for EASE employees, we've authorized Gemini and Notebook LM because we've secured those within our @easy.com domain.
So I think here we need to remember that the legal distinction is control. If you are an EASE employee, you are covered for Playground, Gemini, and Notebook LM because EASE controls those environments. If you're a district employee, you are covered for Playground IEP only through EASE's AI plan and EASE's agreement with Playground IEP. Do not use student data in any other AI tool unless your local district has its own approved plan and has approved the use of that platform. So stick within the safe zone here for EASE for all cooperative business. Anything related to EASE or special ed matters, we're going to only use the approved tools. When we get outside of that, we are outside the boundaries of the law as well as policy.
So our AI plan defines specific permitted uses of using those approved AI tools. So those permitted uses include drafting annual measurable goals, present levels of academic achievement or functional performance, behavior intervention plan language, MTSS documentation, or text leveling. But we'll talk about all of these in more depth to talk about what we need to watch out for. These are drafting supports. Think of them as tools to help you get started, but they all carry inherent dangers that we need to plan for, be aware of, and have a strategy for how to individualize them for our particular students. Prohibited uses include, like Brandon said, eligibility determinations, placement decisions, disciplinary determinations, or drafting a final document without your review, or uploading student data into unapproved AI systems.
And I just want to emphasize that these prohibitions exist because these are the areas that have heightened legal sensitivity. These are the issues where, violations of the law, policy concerns, liability accrues, right? Eligibility and placement decisions trigger the procedural safeguards and the ability to bring FAPE claims. Discipline decisions can implicate manifestation terminations. Automating or shortcutting those processes creates serious legal risk, and we've got to make sure we're staying within the boundaries of the law in how we use these platforms.
We've also identified high-risk uses. Things like drafting behavior intervention plans or text leveling, translating legal notices, any use that affects student rights. And we want to be clear here that high risk doesn't mean that it's prohibited. It just means that it's high risk and increased scrutiny is required. Let me explain a little bit why. Behavior intervention plans are high risk because they have to be grounded in functional behavioral assessment data. If AI generates generic strategies that are not directly tied to the function of that student's behavior, the plan can quickly become non-compliant or ineffective. Translation of legal notices is high risk because parents must receive accurate procedural safeguards and consent information. An inaccurate translation could affect informed consent and potentially invalidate portions of the IEP process. And then there's text leveling, which may seem less obvious, but it's actually one of the most legally sensitive uses. During our internal testing of Playground IEP, we asked the text leveler to reduce the reading level of a passage. In its initial output, the system did not just simply simplify vocabulary and sentence structure, it removed substantive academic content. In other words, it didn't just make the text more accessible, it reduced what the student was expected to learn. Brandon, from a legal standpoint, why is that potentially problematic?
Well, this takes us back to Andrew F., right? And the Supreme Court's requirement and interpretation of the IDEA that IEP must be reasonably calculated to enable that child to make progress appropriate in light of that child's circumstances. And that includes those appropriately ambitious goals and that meaningful access to the general education curriculum. And if that text leveling by the program removes core academic content rather than just simply adjusting readability, now the student's no longer accessing grade level concepts. They're accessing a diminished version of the curriculum, and that can raise serious concerns. It could undermine the requirement that students with disabilities have access to the general curriculum. It could result in a finding that the goals are no longer ambitious. And if this is a pattern, right, that's disproportionately affecting certain groups of students, it can create civil rights exposure under, Title VI, under Section 504. So the legal issue here is not just simplifying language. The legal issue is when it reduces substance. And that's why we've got to stay tuned into that.
Well, and here's an important part. When we adjusted our prompt and explicitly instructed the text leveler to preserve all the key concepts, standards, and academic content, and only to simplify vocabulary and sentence complexity, the tool performed much better. It maintained rigor while improving accessibility. And that illustrates a larger point for us. AI requires good intentional prompting. It requires you to review it, and it requires your professional judgment. Text leveling is high risk, not because it's forbidden, but because small changes can unintentionally lower expectations. Your responsibility is to ensure that us trying to provide accessibility doesn't become a diminishment of what we're delivering. So we've got some safeguards that we're putting in place for these high-risk uses. We want you to be aware of these high-risk uses in AI so that you'll know what to watch out for. And we need you to be that first line of defense by reviewing everything from AI before you incorporate it into an IEP or using it with a student. Additionally, we have a form for reporting issues with AI at easy.com/AI. We'll review any reports of bias, hallucinations, or other malfunctions with the software. You've heard us say this several times already, and it's worth saying again. Never copy and paste AI-generated text directly into the IEP without thoroughly analyzing it. You must ensure that the suggested goals align with the student's actual needs. AI is just our generation's version of drop-down IEP goals. They were a tool to help teachers save time, but used improperly over time, all of the IEPs started maybe looking a little bit the same. It became clear that people were just copying and pasting the suggested goals from the drop-downs without actually making sure that it aligned with the student's actual needs. Let's talk about bias and equity. AI models are trained on the internet, and the internet is full of stereotypes about students with disabilities. Sometimes AI might draft a goal that assumes a student has a lower potential than they actually do. As special educators, you are the experts in understanding your students' needs and developing appropriately ambitious goals. If the AI suggests something that sounds like it's dumbing down the curriculum, you have the authority and responsibility to fix it. AI can replicate historical inequities because it learns from patterns in the information it was trained on. Sometimes that shows up as lower expectations, softer goals, or language choices that frame the student unfairly.
And this bias can be subtle. It may not always be obvious to us. For example, two students with similar baselines get goals of different rigor, or behavior language is more restrictive for one student than another. And this can become a disparate impact issue if that pattern emerges over time.
And our expectation is that you slow down here and ask, does this output hold the same high expectations that I would? Does it match the student's data? Does the tone stay neutral and professional? When you're reviewing AI generated content, you need to be looking for red flags in the language. Watch for words that focus purely on a student's deficits rather than their strengths. If AI keeps using terms like unable to or fails to without balancing those with the student's current abilities and potential, it's a sign that the model is defaulting to a negative stereotype. And we want our IEPs to be a roadmap for growth, not just a list of failures.
I think something else you need to watch for in your use of AI is for what I might call template language. Because AI works on probability, it loves to suggest the most common generic goals. And if the language sounds like it applied to any student with a specific disability rather than this specific student in front of you, it's not going to be legally sufficient. So watch for hidden bias, where AI might suggest a more restrictive environment or a more frequent removal from class for certain types of behavioral issues without a clear, individualized, data-driven justification.
At the administrative level, we're monitoring for disparate impact. This means that we're looking to see if certain groups of students are receiving different types of AI-generated goals or interventions than others. For example, are we seeing softer, less academic goals for students from specific demographics? We have to ensure that the efficiency of AI isn't accidentally creating two different tiers of education within our cooperative.
And remember, disparate impact is a major focus for both OCR and for ISB. Even if you don't intend for it to be biased, if the result of using an AI tool is that one group of students is treated differently than another, then the district could be legally liable. And we monitor this by reviewing the trends in the data. Your job is to be that first line of defense. If you notice the AI is consistently suggesting, easier paths or lower expectations for certain students, you must flag that for us immediately.
And we don't want you just to be aware of bias and that it exists. We want you to have a systematic way to catch it. We've established a 4-step process for every time you generate content to review to make sure that the AI output doesn't have bias. Step 1 is to review the output critically. This means looking past the professional sounding grammar and asking, does this actually sound like the student? Is the AI making assumptions about their behavior or potential that aren't earned? Step 2 is to revise the language as needed. You are the editor-in-chief. If the AI uses deficit-based language like suffers from or incapable of, you must strip that out and replace it with objective, strength-based terminology.
Step 3 is the important legal heavy lifter. Compare to the baseline data. This is where you pull up your actual progress monitoring or your FBA or your classroom observations, and you put them side by side with the AI draft. And if the AI suggests a goal that is significantly lower or higher than what the data supports, you must align it with the data. And finally, step 4 is to submit an AI incident report if a pattern is observed. And as Tony mentioned earlier, you can do that at easy.com/AI. If you notice that the tool is consistently suggesting restrictive placements for certain student demographics, that is a systematic issue that we need to address with the vendor immediately. So that report, submitting that incident report, is going to be an important tool going forward to keep us compliant. Now, when we get to understanding how equity plays here, equity is not an elective, right? It is a legal mandate for us under the Constitution, under the Americans with Disabilities Act, under 504. These laws require us to provide equal opportunity for students with disabilities. And if we use a biased AI tool that results in a student receiving a less rigorous education than they would otherwise be entitled, then we potentially violated their civil rights. And by signing off an IEP, we are certifying that the program is equitable and free from discriminatory influence and free from that, hidden influence of the algorithm. So we've got to make sure we understand that legal obligation that we're providing equitable access.
And at Easy, we want our technology to be an equalizer and not a divider. We use these tools to give you more time to focus on individual student needs, not to let a machine decide a child's ceiling. Our legal and moral obligation is to ensure that every student, regardless of the tools that we use to draft their paperwork, gets an ambitious, individualized, and equitable education. And that's the standard we expect from every special educator. We're now entering what's perhaps the most critical section of this training: data, privacy, and security. In special education, we aren't just handling names and grades. We're handling sensitive medical, psychological, and behavioral data. If this information is mishandled, it isn't just a technical glitch. It's a violation of a family's trust and of a child's right to privacy. This section outlines how we build a digital vault around students' records.
Point. This is where SOPPA and FERPA and the Student Records Act come into play. Illinois Student Online Personal Protection Act, or SOPPA, is one of the strictest in the nation. It requires us to have specific ironclad agreements with every vendor. And as we go through these slides, remember, these aren't just easy suggestions. These are statutory legal requirements that protect you from liability and potential personal liability, and protect the cooperative and your district from costly litigation.
As educators, your privacy obligations don't change just because you're using a new tool. You have a duty to ensure that student information is only assessed by those with a legitimate educational interest. When using AI, this means that you must be intentional about what you input. If a tool hasn't been vetted, you are essentially handing over student data to an unknown entity.
So let's be clear, right? You are the custodian of the data you use. And under FERPA and the Student Records Act, you must ensure that personally identifiable information, that PII, is not disclosed to unauthorized parties. And many public or open-facing AI tools consider anything you type into them to be their own data for use in training. And that is unauthorized disclosure. Our policy is designed to ensure that your use of AI remains a protected disclosure within that legal umbrella of FERPA and the Student Records Act and SOPPA as well.
And this is why we have standardized on Playground IEP. We've worked directly with their team to ensure that they meet our high standard of security. Their system is designed specifically for special education. And that means that they understand the sensitivity of the data they're handling. They have built-in safeguards to ensure that the drafts you create aren't floating around on a public server. They are part of a secure, encrypted workflow.
And specifically, EASE's agreement with Playground IEP includes a signed National Data Privacy Agreement. And that legally binds them to several things. They cannot sell our data. They cannot use it for advertising. And most importantly, they cannot use our students' data to train their global AI models. Your prompts stay within our control. And this is that legal armor that protects us, and that what makes this a tool that is safe for use and legally compliant for use.
And we can't stress this enough. Public AI tools are strictly prohibited for use with student data. This includes the free version of ChatGPT, Claude, or any fun AI apps that you might find on your own. If it doesn't have an easy approved contract, do not put a student's data into it. Even if you think that you've redacted the information to take out all of that student's personally identifiable information, these models are incredibly good at re-identifying individuals based on context.
So if you use a prohibited tool and a data breach occurs, you are stepping outside of the district's legal protection. The district's insurance and legal defense may not cover actions that are in direct violation of this policy. So using a public or open AI tool for professional work involving students' personally identifiable information is a major compliance failure, and that's why the use of those are specifically prohibited by policy.
So let's recap what's on the green list, or the approved list. For everyone, including our 28 member districts, Playground IEP is the authorized tool. And for EASE specific employees, we've also authorized Gemini and Notebook LM. provided you are logged in with your @easy.com account. We have configured these accounts specifically to ensure that the data stays within our Google Workspace for Education Vault.
And the account you use matters. If you use your personal Gmail account, for example, to access Gemini for a work-related purpose, you are violating policy because that personal account does not have the security overrides that EASE has in place to make it legally compliant. So always verify that you are in your professional account before drafting. These approved tools are the only ones where we have verified the vendor's term of service and that complies with our Illinois SOPPA requirements.
And even when we're using our most secure approved tools, we still want to follow the idea of the minimum necessary rule. Just because the tool is secure doesn't mean that we should be reckless. Only input information that's absolutely required to get a high quality draft. If you're drafting a math goal, for example, the AI needs the student's current performance levels in math. It doesn't necessarily need their full name or their home address or their medical diagnosis.
And this is a best practice principle that we borrow from HIPAA and other privacy laws. By limiting the amount of personal information you provide to an AI platform, you automatically reduce sort of the blast radius if there were ever to be a technical issue or a breach. Use initials, use student A, or use other generic descriptors whenever possible. The AI is smart enough to write a goal without knowing exactly, which child it's writing it for. The professional discretion here and using data to the minimum extent necessary is your best tool for maintaining privacy protections.
And now we're going to cover what to do when something goes wrong. Talk about incident reporting, timelines, parent rights, and professional accountability. We've established a formal AI incident report process. You should use this to report 4 specific things: hallucination, bias concerns, privacy concerns, or vendor malfunctions, like if the software isn't behaving as we would expect it to. We aren't looking to punish anyone for these reports. We just need this data to improve our prompts and to hold our vendors to their contracts.
And again, from that legal standpoint, reporting an incident is a protective act. If a parent ever challenges an IEP and we find an error, the fact that you previously reported a similar hallucination or bias to the district shows that we're being diligent. It transforms a potential liability into a documented quality control process. So don't hesitate to flag something, even if you are not 100% sure that it's an incident. It's better to have it on the record that we've taken that potential incident seriously.
And it goes without saying that not all incidents are created equal. So we've established a tiered timeline for reporting. So we've got what we would call high risk issues, medium risk, and low risk. So high risk issues would be things like a potential data breach or a safety concern in a drafted behavior intervention report. We want those to be reported immediately as those happen. Medium risk might be something like a hallucination that affects accuracy. Report those types of things within 3 business days. And then low risk things might be like tone of the writing. If it's those examples that we gave before where it was using maybe deficit-based language versus growth-based language, reporting things like that, because those will be things that we can report back to Playground IEP for them to potentially take a look at their tool.
And these timelines are important because they do align with broader state requirements for data breach notifications. So if we do have a privacy incident or a data breach, the law starts a very fast clock ticking on how quickly we notify parents and potentially even notify the state, depending on the number of people affected. So by reporting those high-risk issues to Tony's office immediately, you ensure that we're meeting not only our policy, but our legal statutory deadlines under SOPPA and other laws as well. So your promptness in that report is what keeps the district in compliance.
Transparency with parents is a cornerstone of special education, and Parents have a right to know that their child's IEP is being drafted in part with AI. So if a parent asks if we use AI, the answer is yes. We use Playground IEP as a professional drafting assistant, and every word is reviewed and individualized by our staff. We want to be proactive in explaining that AI is a tool to help us spend more time with their child, but not a replacement of our expertise. It's also important to note that parents have the right to request that AI not be used for their child. So if a parent requests an opt-out, we must document that request immediately and revert to traditional manual drafting for that specific student. We respect a parent's choice as the primary stakeholder in their child's education.
And by providing an opt-out, that's a massive safety valve for the district. It demonstrates transparency, respect for parent preferences and input, and procedural compliance and fairness as well. So even if an opt-out is rarely used, offering it significantly reduces, our potential vulnerability or liability if a complaint were to occur. It also reassures parents that their child's education is still being designed by you as the experts that they know and trust, with or without the assistance of AI.
With the privilege of using these high-powered tools comes the responsibility of professional accountability. If the policy is ignored, for example, by putting student data into a public, unapproved AI, there will be consequences. Misuse may result in the loss of access to Playground IEP, requirements for corrective training, or further disciplinary action depending on the severity of the violation.
Again, the district is legally obligated to enforce its own security policies. And if we've got a paper policy that we never enforce, it won't hold up in court or an audit or a complaint situation. So, my job as legal counsel, right, is to protect the district and protect EASE. And that means making sure that everybody is playing by the same rules. We provide the safe zone tools, those things that are okay to use, those things that are approved, like Playground IEP, so you don't have to take risks. So staying within that zone of what has been approved is a requirement for your employment and a requirement for your license. So stay in that safe zone of what has been approved for use by EASE.
So to move forward and obtain your Playground IEP account, you must complete 3 final steps. First, you have to finish this training module. And second, sign the acknowledgement of receipt and understanding of the EASE AI plan, which you'll do in our Google Classroom. And third, you have to formally agree and comply with those standards. This creates a clear record that you are informed and a responsible user of this technology.
These steps matter because they document informed use. They establish those clear expectations. So when used properly, AI can support your work. But when it's misused, it does create legal exposure. Professional judgment remains the foundation of special education. So once these documents are filed, we can move forward with EASE setting up your access to this program.
Okay, well, thank you for completing EASE's responsible use of AI training. We believe that by using these tools responsibly, we can reduce your clerical burden and get you back to what matters most, working with our students. If you have any questions about implementation or approvals, don't hesitate to contact me.
And if you got any follow-up questions regarding the legal issues or compliance, again, you can reach out to Tony or to me at our contact information here. So appreciate everybody and especially your commitment to using AI the right way.
All right. Thanks, everybody.